Morning, everyone. Welcome to our webinar. And this morning we are pleased to have Melissa Keys from Indiana Disability Rights. She's the legal director, and she's going to be talking to us about supported decision making, which is a really, really interesting concept. So Melissa, if you're ready, I am going to switch it over to you. If you have questions, please put them in the chat box. And at the end of Melissa's presentation, we will go ahead and answer questions then. So Melissa, if you're ready, I'll switch it over.
Sure.
All right.
Okay, technology is not normally my friend. So can everybody see my screen?
Yes, we can see it. It's a little small. There you go.
There, okay. Perfect. Let me see if there's a way to minimize that. Oh, how do I minimize this?
Push the orange arrow.
Ah, thank you. Like I said, technology, not my friend. There we go. Thank you. Okay, good morning, everybody. Excuse me. My name is Melissa Keys. I'm the legal director for Indiana Disability Rights. I have a master's degree in clinical psychology with a focus on developmental disabilities and serious mental illness, as well as a law degree with a focus on legalese and table banging and collecting student loans. So today we are going to cover some exciting things. First, I'll go over kind of some basics on decision making, and then focus on some options that are available to adults to assist them with decision making, specifically focusing on supported decision making. And then I'll give you guys a case example using the Jamie Beck case. She was the first person in the state of Indiana to have a guardianship terminated in favor of using supported decision making. And then we'll just end with a brief discussion on how you can help, as well as some resources for you guys to move forward if this is something that you want to learn more about. So let's start out really simple. We've all made decisions, right? In fact, we make hundreds, if not thousands, of decisions every day. What to eat, what to wear, whether to answer that snarky email with an equally snarky email. And the decisions that we make, they range in their complexity and the time and the mental resources that we use to make them, right? So for example, the time and energy it takes for us to decide what to eat for breakfast is much different than the time that it takes to make a bigger decision like where we should live or whether or not we should take a new job, that type of thing. But regardless of the type of decision that we make, the process is still relatively the same. It involves understanding the issue, determining the options and the consequences. We gather information, we evaluate those different options and consequences based on the information that we have, and then we decide on a course of action, and then we either communicate or implement that choice, and then we experience the consequences. We move forward. Now, sometimes this process is instantaneous. We don't even know we're going through it, like deciding what to wear or what to eat, things like that. Other times we are much more deliberate. We talk to friends and family, we talk to trusted professionals. If you're like me, you read Amazon product reviews. We do whatever is needed in order for us to feel comfortable in making an informed choice, right? And we are empowered to make those choices and have those decisions respected. We're empowered to use those resources around us. And that's kind of part of the natural human experience of making choices. Now, we've all had experiences, even as adults, where someone has made a choice for us, right? For example, you really want Mexican food for dinner, but your partner orders Chinese food. Even those small choices, when we feel like we haven't been heard or that our choice hasn't been respected or it's been ignored, it can make us feel kind of frustrated. But think about the big decisions in your life: what job you have, where you live, how to spend your free time, what to spend your money on. Imagine how it might feel to not be able to make choices about those important areas of your life, or to not even have input. And that's kind of the framework that I want to have kind of underlying our conversation today. So in its most basic understanding, supported decision-making is a way to accommodate the decision-making process. And supported decision-making, people who need support choose appropriately named supporters. Those are generally trusted friends, family, or caregivers. These supporters help them through that decision-making process that we just went through. However, with supported decision-making, the person has all decision-making authority. It's a way to increase empowerment and assert self-determination. And as we've discussed, this concept itself is not new. It's kind of how we all make major decisions anyway. But the formalization of it, the writing down of a plan and having that plan recognized as a valid way for a person to make decisions is what's new and what we're seeing increasingly across the country. So it's very exciting, and we're hopeful to bring this to greater awareness in Indiana. So who can use supported decision-making? The short answer is really anyone, because like I said, it's the concept of how we normally make major decisions anyway. But for those who are currently under guardianship or who are currently using other decision-making arrangements, it can even be used within those arrangements as a way to practice decision-making skills and maximize the person's input, independence, and self-determination. While the concept of formalized supported decision-making really started with people with intellectual and developmental disabilities, it can really be used for any disability or condition, including those with mental health issues, those recovering from addictions or traumatic brain injuries, and those who have cognitive decline due to aging. And I want to talk briefly about this issue of capacity, because there's a lot of different legal standards for capacity, and that is what is the crux of the decision when it comes to guardianship, right? It's, does this person have quote unquote capacity to be able to take care of themselves across a number of different areas? So when we think from a legal perspective, there's, capacity to consent, there's capacity to contract, there's capacity to sign a power of attorney. And it's important to note that capacity is not a yes or no. It's not you either have it or you don't. You cross this magical line and all of a sudden you go from not having capacity to having capacity. It's really a spectrum, right? So think about it in terms of that. So whether someone has capacity is really determined by the situation, the complexity of the issue, as well as some internal and external factors, time of day, physiological state. Anyone who's ever gone grocery shopping while hungry, you understand that you make much different choices than you do when you're not hungry. Timing of day is also important. You ask me a question before 8 a.m. and you're going to get a completely different answer than you will at 10 o'clock at night, because I am a night owl and I think mornings are for terrible people who I will never understand. It also relates to the person. Their alertness may change based on when and what type of medication they've taken, how much sleep they had the night before, whether they are currently experiencing symptoms, active symptoms of their condition, if their condition has periods of active symptomatology. Capacity can also change over time based on skill acquisition. So we all know that the more you learn or practice something, the better you get at it. And the same is true for decision making. Something that might seem completely foreign at first, after the person has practiced and had more exposure to it, they might become more able to handle that independently. So all of these factors, all of these different pieces come into determining whether someone, quote unquote, has capacity. And here's kind of an example. So I have a driver's license, right? So that means that the state of Indiana has said that I have the basic capacity to drive a car. In order to demonstrate the capacity, I did not need to prove that I knew everything about how a car engine was built. And I also didn't need to be a professional level driver. I didn't need to drive around the Indy 500 like Danica Patrick. I just needed to meet those minimum requirements to show that I could safely operate the vehicle without, killing anybody or destroying sidewalks or something like that. Now, my driving skills have, for the most part, gotten better since I was 16 when I first got my driver's license, right? And there's been advances in technology that have helped people like me who are terrible drivers normally be better drivers. So, for example, cars have automatic parking and parallel parking, and they'll alert you when you start to drift out of your lane. So using all of these different technologies, as well as my experience, has allowed me to gain increased capacity in driving the car, right? But even across that, my capacity to drive fluctuates. driving late at night, if I haven't had much sleep, or if it's bad weather, or if my kids are in the back screaming at me to open snacks or change the radio station or whatever. It's much different. I'm a much different driver than driving on a clear day with no distractions. But the state of Indiana hasn't put restrictions on my ability to drive, right? They haven't said, you can only drive when you aren't distracted on clear days with no kids in the car, because frankly, nobody would ever get anywhere, right? They also haven't said that, you need to be able to rebuild a transmission or know every single way that your car functions in order to be able to drive. It's understood that I'm going to seek help for things that are outside of my wheelhouse. I can consult with a mechanic. I can look up things online. But unfortunately, the same isn't always true for decision making. Oftentimes, people with disabilities have to prove that they can make decisions covering a wide variety of areas and increasingly complex decisions at all times under all these different circumstances in order to maintain their ability to make decisions independently. And the point is, when we talk about capacity, we really need to think of it as a spectrum, not a yes or no, keeping in mind all of the different factors that go into deciding whether or not someone has capacity, and thinking about what is really that baseline needed in order for the person to be able to make decisions themselves. Do they need to actually know how to physically make that decision, or do they need to know how to access the resources in order to be able to support them in making that decision? And I can't see if people are raising their hands, so you're not going to get in any trouble, but who here has been in a meeting where someone has said, once the child turns 18, the parents will have to get guardianship or else they won't be able to participate in, insert service there, educational decisions, medical decisions, service decisions, what have you. And it happens a lot. And what I want people to be aware of is that with very limited exceptions, there are no services or supports or benefits that require someone to be under guardianship in order to access them. And I want to make sure everyone is aware that there are options other than guardianship in order to have a loved one participate in someone's care or planning or treatment activities. And please don't get me wrong, guardianship is definitely a necessary tool. That's why we have it, right? But for those who are just getting guardianship as a way to be able to participate in a loved one's life, there are other much less restrictive ways in order to do that. And again, our goal, and this is not an unfamiliar concept to you all, our goal here is to make sure that everyone has an opportunity to participate and make decisions about their life to the greatest extent possible and in the least restrictive manner possible. And like I said, these are not unfamiliar concepts. So let's talk briefly about some of these different options, how we can help support people. And I want you to keep in mind that a lot of these tools can be used in combination. They can change over time based on the person's individualized needs. And they can be really flexible with certain exceptions. So for those of you who are visual learners, this is what I call the spectrum of assistance, going from least restrictive to most restrictive. So starting with the least restrictive, this is what you think of independence, or some people call it interdependence, as well as informal support. This is ways to kind of help fill the gaps in someone's needs. So for someone who has a hard time remembering to pay bills, you could set up automatic bill pay or direct deposit, using credit cards with low limits or store-specific gift cards to help people who need help budgeting, using all kinds of apps. There's smart technologies to help people to remind them to take medication. There's smart home technology to help people live independently. There's refrigerators that will remind you when you need to buy groceries and what kinds of groceries. And there's doors that you can lock and unlock remotely if you feel like you've forgotten, whether you've locked your doors or not. You can close garage doors. There's all kinds of technology out there to help support people living independently. There's also, having a network of friends or family that will kind of provide some informal support, that'll check on the person, that'll be there to help answer questions or to help them if they need a little bit of support. Creativity is really kind of the key here. And it's anything that can be done with minimal involvement or intrusion into someone's life that will help support them to be independent. Next, we have formalized supported decision-making, which again is a way to accommodate that decision-making process that still allows the person to make the decision themselves, but having support in order for them to do so. And in supported decision-making, the person chooses not only the areas where they need support, and this could be anything, finances, healthcare, legal matters, services, education, employment, community living, recreational and free time, romantic relationships. Whatever the person needs help or assistance in making decisions, they can customize their plan for them. The person then chooses his or her supporters. These are generally trusted friends, family members, or caregivers. And then they also choose how they want support to be given. So, for example, giving the person information in a way that they can understand. If they have difficulty understanding large words, it could be helping them discuss the pros and cons of a particular choice. For any of my list makers out there, it could be, helping them write down what the different options or consequences are. And, there are tons of different ways that supporters could help support the person. It could be that the person gets overwhelmed in medical situations and can't process the information that they're being given. So they might say, hey, supporter, can you come with me to my appointment and help me, write down what I need to remember so that I can go back and process it later, or help me think about ahead of time what questions I'm going to need to ask, or remind me of things that I want to tell my doctor, or it could be, I really need to buy a new car. I want you to help me. I get overwhelmed when I go to the dealership and I don't know if I'm when they try to sell me the add-on warranty package, I'm not sure if that's something I need. So come with me to help me understand what questions I need to ask or what information is good information. It can be anything to help support the person to be able to make the decision themselves. The formalization of it, when we talk about formalized supported decision-making, generally means writing down that person's plan into a document called a supported decision-making agreement, which we'll touch on briefly in a second. These arrangements can be changed as needed. They don't require a court to get involved. They can be very flexible and change over time. And like I said, they're just a good way to support someone who needs that additional ability to have that support to make decisions themselves. Next are agency agreements, and this is where a person has the ability to appoint someone else to make a decision for them. This is what you typically think of for powers of attorney, healthcare representative, representative payees, and really depending on how the document is written and the type of document, that really kind of dictates how that relationship works. They can generally be revoked by the person, except under certain circumstances. They also don't require court oversight or involvement generally. They're also just generally a good practice to have in place for anyone as part of advanced planning. For most of these, it's really wise to consult with an attorney to make sure that the document complies with the laws and that it's drafted in accordance with the person's wishes to make sure that it's doing what they want the document to do. Up next, I'm going to kind of talk about limited guardianship and guardianship together. Guardianships are a legal process involving courts. There is no way to get guardianship without getting a court approval first. Oftentimes you'll hear parents say, oh, no, I'm his guardian. And then, you'll start to dig and say, oh, when did you go to court? Where are your letters of guardianship? Oh, no, it's because I'm his parent. Well, that doesn't work. In order to have guardianship, you need to go to a court and have the court issue letters of guardianship. There are different types of guardianships, but I want to, be very clear about what it is. Guardianship is substituted decision-making. It means that the guardian stands in the legal shoes of the person over whom they are guardian for. It's used when a person can no longer make or communicate decisions about their life or their property. Like I said, guardianship is a very necessary tool, but for those who do not need that level of intervention, there are much less restrictive ways to provide that support. Limited guardianships are guardianships generally over just the person, meaning dealing with issues about where they live or their medical treatment, or there's guardianship over the estate, which deals with property or assets, finances, things like that. In the areas covered by the limited guardianship, the guardian makes all the final decisions, but the person retains decision-making authority in all other areas. There's also things like temporary guardianships, where a court can grant decision-making authority to someone for just a limited amount of time. That can be useful if guardianship is just being used to get somebody into treatment, and once they get stable on their medications or once they get rehabilitated, they no longer need that level of intervention. The guardianship automatically terminates after a certain period of time. And then, excuse me, full guardianship means that all decisions, both person and estate, are made by the guardian. It's also sometimes called a plenary or full guardianship. One thing to also know about guardianship compared to some of these other options is that it's really difficult to terminate or get rid of a guardianship. There's only two ways to do it. One is if the person under guardianship dies. Again, if the guardian dies, that does not terminate the guardianship. It just means the court is going to appoint someone else. And then the other way to terminate a guardianship is showing by clear and convincing evidence that the person has regained capacity and no longer meets that definition of incapacitated person under Indiana law. That can be very difficult and expensive to do. It often involves having to have medical or healthcare experts to testify, and it can be quite expensive to do that. I just wanted to note briefly that there are some other decision-making models. There's things like shared decision-making or team-based decision-making, and that's where the decision is made in coordination with others. The team kind of comes to a consensus about, what we're going to do. You'll sometimes see this in like treatment team planning or in the medical context as a way to get informed consent. There's also other decision-making support arrangements. There's, things like trust accounts, protective orders, advance directives, living wills, psychiatric advance directives. There are all kinds of things. People should really be encouraged to talk to an attorney who specializes in this area so that they can discuss all of the different options that are available and find what is really going to help them be as independent as possible while still getting the support that they need. The other thing that I want to note is that this concept of supported decision-making, of accommodating that decision-making process, really can and should be used throughout any of the other options that we've talked about. So even used within that guardianship context, it can be a way for the person to gain skills in decision-making, which could eventually over time lead to less of a need for guardian, or maybe moving a full guardianship down to a limited guardianship. So I want to focus briefly on the difference between power of attorney, supported decision-making, and guardianship, because I think sometimes they tend to get kind of confused. So powers of attorney, they're really useful tools that we talked about them briefly, but in essence, and depending on how they're drafted, they grant decision-making authority upon an agent called an attorney in fact. They can be written to address a number of circumstances. They're really flexible. They're well regulated in the law. And there are some states where powers of attorney have been carefully drafted to address supported decision-making. They include, principles of supported decision-making within the power of attorney relationship. And they're really useful, but they differ significantly from supported decision-making in one major way. So in supported decision-making, the person retains the decision-making authority. They make the final decision. The person works with their supporter, but ultimately they are the one that makes the decision. There's a tendency, even with the most carefully crafted power of attorney, to think about its common context and assumption, namely that the attorney in fact has been granted decision-making authority. So it could be used as a way to supplant the decision-making authority of the person when it is not meant to do so, just because it's called a power of attorney. So that's something to keep in mind when you're thinking about this. Supported decision-making, on the other hand, it's an entirely different notch on that spectrum of assistance. It does not grant anyone decision-making authority, right? It just structures the decision-making as support that the person needs in order to make their own decisions. And then, of course, guardianship is where a court appoints someone to make a decision on your behalf. So if you think about it, supported decision-making is I make decisions myself using a supporter. Power of attorney with supported decision-making principles might be something like I make decisions using my supporter, but under these certain circumstances, I appoint Bob to make decisions for me. And then a straight up power of attorney would be something like, I appoint Bob to make decisions for me in this area. And then guardianship, of course, is a court has appointed Bob to make decisions for me. So one of the biggest questions that I hear about supported decision making is what protections are in place to keep people from making quote unquote bad decisions, or to keep them from being abused, neglected, or exploited. And so I want to kind of address a few of those concerns as well. So decision making is not a skill that we're born with, right? Anyone who's spent more than 5 minutes with a child knows that. It takes a lot of time, it takes experience in order to really cultivate your decision making ability. And here's an example, and recall that I am at best an adequate driver. Well, in college, where we all know that great decisions are made, I decided to test fate by seeing how long I could go with my tank on E. It didn't start out that way. I was late for class. I didn't have time to stop. And then, I was in a hurry to get home after class. But I went like 2 or 3 days with that needle just pushing it on the E. And then finally off campus on my way home, my car just died. What should have been a $20 fill-up turned into a $75 tow to a gas station, a $20 fill-up, and, a really embarrassing call to my parents. Now, after this incident, the state didn't take my license away. They didn't say that I can't drive anymore. They didn't condition my driving on always having over half a tank. No, I was able to learn from my mistake and move on. I had that dignity of risk. Unfortunately, people with disabilities are often not given that same dignity to make mistakes, and they may find themselves in a position where their ability to make mistakes is questioned for these quote-unquote bad choices that either many of us have also made, or that we've also, they haven't been given the opportunity to learn from those mistakes and move on. And again, I can't see hands, but how many of you have heard or even said the phrase, well, he's an adult, he can do what he wants, right? And it's usually a he. I'm not, not bashing guys out there, but you'll notice that you never hear it or you never say it when someone is making a good choice. And when I say good choice, I mean something that you yourself agree with or that you think a reasonable person would make. It's not necessarily based on their ability to make decisions, which should be the determinant, but it's based on your value assigned to that decision. And here's kind of an example. So my dad has smoked a pipe his entire life. It's gross. I don't agree with it. It's unhealthy. It's expensive. He's been told his entire life to quit smoking by everybody. Mom, doctors, friends, family, sister, everybody has said, you really need to stop smoking. It's unhealthy. But no one has ever said, you're making an unhealthy choice that a reasonable person wouldn't make, so I'm going to get guardianship over you because it's clear that you can no longer make decisions related to your health. That's silly. That's not how we treat people. But oftentimes people with disabilities are held to that higher standard. They don't get that dignity of risk that my dad enjoys. They don't have their choices respected automatically by doctors or service providers. And this burden of low expectations is that we assume that people with disabilities won't make a good decision or they don't know how to make a decision, so we don't even give them the opportunities to do so. And then we're surprised when they make a quote-unquote bad decision, and we have this knee-jerk reaction like, well, that didn't work. I guess they can never make a decision in that area again. And again, that's not how we treat the general population. It's not how we should treat people with disabilities. I mean, I'm sure there's not many of us who would want our decision-making skills evaluated based on decisions that we made when we were 19. In fact, I would argue that probably many 18 to 21-year-olds should be under guardianship to begin with because we're not good at making decisions yet. And people with disabilities deserve that same dignity of risk that we all enjoy. So rather than putting this high standard of, you've got to make good decision-making 100% of the time, or else you need a guardian to make decisions for you, there are ways to lessen those risks that people face in a much less restrictive way than jumping straight to guardianship. For example, using some of those less restrictive alternatives. There's also ways to help people practice and learn in a safe environment so that they have more abilities to make decisions. And here's another secret. Guardianship is not an impenetrable shield. It is not a chastity belt. It is not a bank vault. It is not going to force someone to take medication that you think they need to take. Bad things can and do happen. It's just an unfortunate part of the world that we live in. There's no guarantee of safety under any arrangement, including guardianship. But that is not a reason to limit the options that are available so that people can live their best lives, right? Instead, people should be empowered to use their voice, have their voices respected, And that means if abuse, neglect, or exploitation does happen, having their stories believed and holding the perpetrators accountable. And studies have shown that those who are empowered, those who have the ability to make their own decisions, have their voices heard, they're actually less likely to experience abuse, neglect, or exploitation compared to those who experience learned helplessness, like what happens when someone is not allowed control over their life. That's associated with an increased likelihood of increased symptomatology, anxiety, depression, loneliness, all kinds of things. It's much better to teach someone how to identify toxic or abusive or exploitive behavior than to rely on someone always being around to do that for them, because eventually they either won't have a person in their corner, or worse yet, they'll have the wrong person. Supported decision-making in particular also has that added bonus of oftentimes having a team involved in the person's care. There are often several supporters named, and they can kind of act as checks and balances to ensure that the person's not being abused, neglected, or exploited. And then I would remind you that with supported decision-making, the person retains the right to make all of their own decisions, unlike powers of attorney or guardianship where someone else is making a decision for them. So that means that no one else is allowed to make decisions for them, unlike with agency arrangements and guardianship. And that's huge in being able to support someone's self-determination, and is a good way to help guard against that abuse, neglect, and exploitation. And then lastly, Indiana is a mandatory reporting state, meaning that people are required to report to Adult Protective Services if they become aware of abuse, neglect, or exploitation of a vulnerable adult. Okay, getting back quickly to supported decision-making agreements. So we've talked a lot about how the concept of supported decision-making is kind of what we naturally do anyway when we're making decisions. And, when you're deciding what kind of car to buy, you don't necessarily write down, I'm going to talk to my brother, I'm going to look up Kelley Blue Book and Consumer Reports, I'm going to go to these 3 different dealerships, and I'm going to test drive these 4 different types of cars. Probably not. You just kind of go through the motions and you do it. You don't have to write it down. But for those who need additional support or structure, that might be a really necessary tool. So currently in Indiana, supported decision-making agreements do not need to be on a special form. There is some legislation in place. There's not a form required, but there would be some different components required in order to make a valid form. And so if the legislation passes, keep an eye out for my organization to provide some additional information about how to make a valid supported decision-making agreement. So these agreements, they not only provide a reference point for the person who needs support, but it also provides structure to the supporter. And it can be used to show third parties like doctors or service providers who might be questioning that person's ability to make decisions, that they are in fact able to make their own decisions and have those be recognized, even if they're using accommodations to do so. Some common components of the form include, acknowledge of the way the relationship will work, identification of the supporters and the areas of the person's life where support's needed, and then also the manner that they want support. There's also generally a way to reference any other decision-making arrangements or supports that the person wants kind of reference. So for example, if they have a trust account or if they have a representative payee and they still want to keep and maintain that service. And then finally, there's usually an acknowledgement by the supporter of their role and responsibilities. And then lastly, that form is generally signed and notarized or witnessed. And then there's, generally reference to rules and responsibilities regarding mandatory reporting as a way to include some additional oversight. So next, I want to talk to you about my friend Jamie. So in 2010, Jamie was found by Adult Protective Services literally wandering around the town of Economy, Indiana by herself. Her father had passed away 3 days earlier, and Jamie had no other family members to care for her. She wasn't connected to any services or supports, and she was really alone. She didn't have any income or really any way to kind of provide for herself. So APS placed Jamie in a local nursing home at the age of 19, and she was appointed a guardian. While she was in the nursing home, it took Jamie over a year to get a CIH waiver, a community integration and habilitation waiver, after which time she moved into the community. She got into a waiver home She began pre-employment services working at a sheltered workshop, but she wanted more. She tried to find a job, but she ran into problems because she only had a certificate from high school as opposed to a diploma. But Jamie was able to advocate for herself in front of the Richmond City Council, and she got a job the next day at Pizza King, where she worked for a very long time. But she wanted a full-time job. So she applied for training at the Erskine Green Training Institute in Muncie. And then before she graduated, she was offered a full-time job from Ball Memorial Hospital, making $11 an hour with benefits. So Jamie, once she got connected to those services, her life really just, took off. During this time, while she was kind of going through all this, Jamie's guardian brought her to our project where we were piloting supported decision-making. I met with Jamie, and together we helped draft her plan and work with her supporters. And then on June 13th, 2018, we went before Judge Gregory Horn, and we successfully terminated Jamie's guardianship, making her the first person in the state to do so in favor of supported decision-making. And even though all of the parties were on board, it still took a tremendous amount of resources, right? We still had to present medical testimony from her primary care doctor that Jamie had the ability to make decisions herself. We had to put on several witnesses that could speak to Jamie's ability to make decisions herself. We had to put forth all of this evidence to really show that she was able to make decisions. And if you think about it, that's it can be a very tall order to do. And this was with everybody, being very supportive. Some other things that I want to mention about Jamie's case, imagine being 19 and in a nursing home, and kind of how that might speak to a little bit of a failure of the system for not having Jamie connected to services after she left high school. And it's important to keep in mind, when she wasn't connected to services, when she was, literally wandering the street, guardianship may have been the most appropriate tool to be able to help her get where she needed to get. But as she gained skills, as she started working, as she started getting connected to services and building her support network, she no longer needed that high level of intervention, and we were able to use that evidence to help make the case to go to a lesser level of intervention. The other thing that I want to notice is, had she had a different guardian, her guardian was so supportive of her getting out of the nursing home and getting a job, and he supported, all of the different choices that she wanted to make. But a different guardian, it could have ended up in a very different way, right? It could have been the guardian said, Jamie's no longer on the streets. She's in a facility. She's being cared for. Perfect. I'll sign the paperwork. And it might be that Jamie would still to this day be in that nursing home. So it's really important that people are aware not only of the different options that are available to help support someone, but what it also means in the long term, and how even those with best intentions of protecting and making sure people are well cared for can ultimately not help them regain the independence that they are most able to have. So I want to talk just briefly about how you all can fit in. So talking to families, talking to people with disabilities early and often about different options that they have, pushing back if you hear people encouraging guardianship as the only option, especially if a less restrictive option might work. This is key, encouraging opportunities for decision-making all the time, encouraging the person, your clients, students, whomever you're working with, to be a part of their planning, their treatment planning, their meetings, building decision-making into whatever curriculum or goals that the person has, encouraging the person to be an active participant to the greatest extent possible, even if they are under guardianship, and then supporting that person's decisions, because nothing is more demoralizing than communicating a decision and having it be ignored or discounted. And then finally, referring families and people with disabilities to good resources so that they can learn more about the options that are available to them. I wanted to end briefly so that we had plenty of time for questions. I wanted to briefly mention Senate Bill 380, which is currently before the Indiana General Assembly. And that bill does a few things. One, it would allow for supported decision-making agreements to be recognized as a valid way for someone to make a decision. Second, it would require petitions for guardianship to include a statement about whether less restrictive alternatives have been considered. They don't require that less restrictive alternatives have to be tried. It just, it wants people to give the court information about whether they've been considered, if not. And then third, it would require in the biannual accounting that guardians are required to do for them to provide information on whether guardianship is still necessary or if a less restrictive option might now be better. And then here are some really great resources. I'm going to do a plug for Indiana Disability Rights. Our website, we have started a supported decision-making specific page. We are currently working on developing some videos that will hopefully soon be available, but we've got some other resources. And then here is my direct contact information in case people have specific questions that they want to ask, or if they want resources or more information. And I would be happy to send this slide deck along so that you guys can have it, so you don't have to be fervently writing down everything that I'm saying. So with that, I'm happy to open it up to questions. Let me see if I can get that.
Let me see. We did have one question that came in while you were speaking. How hard is it to change from guardianship to another level of guardianship? So if somebody goes from that total guardianship down to, say, like just the financial.
Okay, so transitioning from a full guardianship to a less restrictive guardianship, you still have to make that same showing, because what you're basically saying is that they no longer meet that definition of incapacity for that specific area of their life. So you still have to show by clear and convincing evidence that they no longer meet that definition. So you still have to, put forth evidence, including testimony. You may have to have experts, depending on the circumstances. It can't just be that the guardian shows up and says, hey, they no longer need a guardian, I'm withdrawing my guardianship. It doesn't work that way. The court still has to make a showing of proving that they no longer meet that definition.
And then somebody asked, do you have to pay for limited guardianship?
Yes. Filing guardianship, regardless of whether it's limited or full, there's still a filing fee. And then there's also, an attorney fee. Guardianships can range depending on what county you're in and the attorney that you're using and the level of guardianship that you're looking at. They can range anywhere from $1,500 to $3,000. If they are contested guardianships, meaning that either the person doesn't want to have the guardianship, or if there are two or more people actually, who are competing to be guardian, it can be a lot more expensive than that because, again, that generally involves more experts, more time and evidence that needs to be presented. So contested guardianships could be as much as $10,000, $11,000, depending on things like that. And then, of course, the process to terminate a guardianship is also very expensive as well.
And then in terms of pro bono agencies, for those that can't afford guardianship, like I know in Fort Wayne we have a couple agencies, but those are all typically based upon ability to pay. Do you know of any that do pro bono that aren't based on ability to pay?
Many of the county-based bar associations, so Marion County has a huge one. I'm sure some of the smaller counties may combine for that, but they'll have what's called a modest means. I'm not county council, something like that, and that's for people who need maybe either reduced fee or sliding scale fee or pro bono work. You can sometimes ask the county bar association. So in Marion County, it's the Indy Bar, the Indianapolis Bar Association. There's also, Hamilton County. Every county generally has one. You can ask for modest means referrals, but oftentimes those aren't, I hate to say it, but sometimes, you pay for what you get. It's really important to have an attorney who is knowledgeable and qualified to speak to the different options that are available. My organization does a lot of options counseling, meaning that we will talk with families about what different options are, but we only represent people with disabilities. And when people are filing for guardianship, it is the guardian that is being necessarily represented. And so we don't file petitions for guardianship. We only, help represent people with disabilities. That's our funding restriction. So we are not able to petition for guardianships on behalf of people. Indiana Legal Services does in some counties offer guardianship services. But otherwise, yeah, it can be very challenging to find affordable legal resources.
Other questions? Anyone else have any questions this moment?
And like I said, I will send out the slides. You guys are more than welcome to email me or give me a call if you've got specific questions that you don't necessarily want to, write a chat about. And I'm happy to do that.
Okay. And yeah, you can just send those slides to me, Melissa, and I will distribute those. I have a list of all the attendees this morning. And we thank you so much for your time and the information. Lots of really, really good information there. And I'm sure it's going to be really beneficial for all the people that we work with and serve. So no further questions have come in, and I don't want to keep people any longer than necessary. So thank you all this morning, and have a wonderful weekend. And just to let you know, for your attending, if you are hoping to get credit for this webinar through your employer, you will receive a thank you for attending webinar, and that will serve as your verification of attendance. And that should be sent out typically within an hour after the webinar. It could be within the next day, so please be patient. All right, well, thank you very much, and have a great day. Bye-bye.